So good morning still, everyone. We are live. It is Tuesday, March 19th in Senate Economic Development, Housing and General Affairs. It is crossover week plus finance crossover week. I always forget exactly what this is, but we still have one more item to get out of committee, and we don't need any special dispensation to do that because it is a constitutional amendment. We moved the vote to tomorrow, which I think was smart, even if we didn't know the floor was going to go long, because floor will be in the afternoon, so at least we are guaranteed our morning to work on things. But what we do have time for is to have Damien walk through a very useful side-by-side he's done of Illinois that has passed this language, us that are considering it now, and Pennsylvania that has it under consideration as well.
Oh, it does.
To get his assessment on the mostly stylistic differences or entirely stylistic differences he sees between the three, which I think is every word matters in this context. So we want to be able to defend, every piece of language, every comma, every and. So we'll just walk through those with Damien in our 25 minutes before lunch.
Great. Thank you. For the record, I'm Damien Leonard from the Office of Legislative Counsel. So you're all getting the side-by-side in front of you. Without reading it, just by looking at where the words end up on the page, you'll be able to tell that Illinois and Pennsylvania are literally identical. Down to the words and punctuation, everything is identical between the two. Vermont is differently worded than them, but I think my assessment is that the difference is stylistic. You may hear other opinions. But I'll read you the differences. So there are two sentences. The Illinois sentence is employees shall have the fundamental, and I'll actually break it up into pieces. So the Illinois starts, employees shall have the fundamental right to organize and to bargain collectively through representatives of their own choosing for the purposes of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety at work. So the first sentence can be done all together. Vermont's version is that employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace. There are some wording differences. In Vermont, we start with the that you see there. It's an old-fashioned style. But that makes it consistent with our other amendments, and that's how we've moved forward. So Illinois and Pennsylvania have a fundamental right to organize and to bargain collectively through representatives of their own choosing. We say employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing. The rest of the words are essentially the same, except we say workplace, they say at work. We say safety in the workplace, they say safety at work. So I think the first sentences, words are different, but they're essentially identical. Do
you want questions as we go along, or you want to wait?
Why don't we wait till the end?
Okay.
Let's break it up. Let's go ahead and do that.
We say organize or join. I'm sure, obviously, we don't mean you have to choose one or the other, which or sometimes does.
Yes. So they have a right to organize. They also have a right to join an existing labor organization.
Okay.
You do not have to. So, for example, you can be an independent union, or you can be part of one of the larger national unions.
Okay.
And organizing also refers to concerted activity, which is expressly protected under the National Labor Relations Act. So, for example, employees discussing conditions in their workplace is protected, even if they do not choose to unionize. So you cannot fire employees for saying, God, the air conditioning's been broken 115 degrees here. I don't think this is healthy. you can't fire employees for having that discussion and then coming to management to ask for, better ventilation or something like that.
And that's under organized, that
Yeah,
type
so-
of speech would be under organized.
Yeah, so, we added the or join a labor organization. But the right to organize is covered in all of them. To join a labor organization, I guess, stands out as a difference. And then they say to bargain collectively, we say for the purpose of collectively bargaining.
So we see a value, obviously, then in joining a labor organization, which means, I mean, to me, it would be obvious that you would need that if you're going to have a labor organization. It wouldn't make any sense if you couldn't join it, but
Right, so I see there being somewhat different, somewhat of a difference between just organizing and joining. So I think I don't know that changing it to just have a right to organize would detract from it. But I do think joining a labor organization can be read to cover more than just organizing.
so it's more protective of the employees.
I think it can be read that way.
Okay.
I won't put
Okay.
myself in place of the court. I think that
So I
you
can
can,
read it that way.
yes, I think you
Okay.
can argue that this protects the right to join a union, which is protected under our laws. So, for example, if you look at some of our statutes. Here, let me just pull up SELRA, the State Employees Labor Relations Act. So under employees' rights, we say employees shall have the right to self-organization, to form, join, or assist employee organizations, and to bargain collectively for representatives of their own choice, and to engage in concerted activities for the purposes of collective bargaining or other mutual labor protection. So we in our own statutes separate out self-organization and forming, joining, or assisting labor organizations. So that's part of where we drew this language from.
Great, thank you.
So. Okay, so getting back to the side by side, in the second sentence, I'll start with the first half of it first. In Illinois and Pennsylvania, they say no law shall be passed that interferes with, negates, or diminishes the right of employees to organize and bargain collectively over wages, hours, and other terms and conditions of employment and workplace safety. And we say, therefore, no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain with respect to wages, hours, and other terms and conditions of employment and workplace safety. The main difference really is they say no law shall be passed. We say therefore no law shall be adopted. Otherwise, we use the same interferes with, negates, or diminishes, and the same references to wages, hours, and terms and conditions and workplace safety. The only other difference is that our style guide makes workplace one word, theirs makes it two, which is a very minor grammatical difference. Questions on that? And then that brings us to the final clause here. Their laws provide, including any law or ordinance that prohibits the execution or application of agreements between employers and labor organizations that represent employees, requiring membership in an organization as a condition of employment. So this is the agency shop or union shop. I'm sorry, this is the anti-right to work legislation that permits agency shops and union shops, or prevents them from being banned. And we say, or that prohibits the application or execution of an agreement between the employer and union representing the employees that requires membership in a labor organization as a condition of employment. So again, it gets to pretty much the same exact place, but uses slightly different words to do it. Part of it being our slightly more antiquated tone that we use. in our constitution.
That makes it blend with the Constitution, not stand out as, this is some modern tack on that they don't even speak the same.
Yeah, and I mean, to be fair, you know, certainly in the case of Illinois, it's a younger state. And a lot of younger states have more modern sounding constitutions. And our constitution has an older tone that we've retained. You know, since joining. Pennsylvania is older than us, but I can't speak to that, but certainly with Illinois originating this amendment, it's not that surprising that they would use more modern language than us.
So did you say those were adopted already?
Illinois is, Pennsylvania has made it through one body and is awaiting action in the other body. It's not clear to me whether or not it's going to advance. But they, like us, have a similar process where it has to go through both bodies. And I think Pennsylvania may require two bienniums in a row, just like we do, but don't quote me on that. But they're in a similar place to us. They're starting the process, and they've just made it through the first house, and they're waiting second. Any other questions?
There are certain occupations that are not covered under the National Labor Relations Act, such as farming.
Yeah.
We don't have anything specific here in Vermont, do we, that brings farming in, other than what this would do?
So we do have a proposal that left the Senate last year that is in the House now that would allow farmers, or not farmers, but agricultural workers to organize and collectively bargain. It's not clear whether that'll make it out of the House.
Is there anything else or any other group that is left out?
Yeah, there are
They-
domestic workers, and then and agricultural workers are the two big ones. I have to look at the NLRA to remind myself if there are other groups.
Oh, and I'm wondering in terms of this amendment, what groups would this amendment effectively extend the ability to unionize to that don't exist now
So I think
under state law?
to extend the ability to unionize, you would need to extend state law. So we can't replace the NLRA. So if there's a group covered by the NLRA, the other
But
big
not
group
covered.
that's
They're not covered by the NRA.
right, the other big group that's not covered by the NLRA is public sector employees. And
We have
those
laws that relate to public sector employees.
we do. Our public sector laws do not cover your employees in this building. So but I think it's an interesting question. I don't know that this has come up in Illinois yet as to any groups who are not covered by their laws or the NLRA asserting that they have rights under the amendment. The amendment does say that employees have a right to organize and join a labor organization. So there would be an argument for example, groups like legislative employees who do not currently have rights, that they could assert a right.
They're not considered public employees.
We are, we're just, so with public employees, we've created a law for each group that we've granted rights to.
Mhm.
So, the way it works is that different states grant rights to different public sector employees. So many states, grant the right to teachers, but not to others. Some grant them to law enforcement. I think California might be the only one that, and don't quote me on this, but they just extended it to legislative employees effective 2026. So they might, assuming they've covered all their other public sector employees, they might be the only state that covers everyone. But I'm not 100% sure. And then traditionally, collective bargaining has not extended to employees who are confidential employees or management because of the just the conflict that exists for a manager to be effectively bargaining with
In a way, what I'm
themselves.
trying to get at is, are there any unintended consequences that may result from a void in federal law as well as a void in state law that this winds up superseding? For example, if there are employees such as domestic employees who are not covered under the NLR, National Labor Relations Act, and are not mentioned anywhere in Vermont law, would they automatically be able to collectively bargain under this constitutional amendment and have the right to do so?
So, I'm just pulling up the summary of the NLRA. So your exclusions are domestic workers, agricultural workers, public sector workers, independent contractors, and supervisors. And I believe that's it.
Come up. I remember, I think it was with childcare workers or the home health care, the people you hire in state funding to work for.
Yeah.
We had to give the childcare people, we would be responsible because otherwise it's price fixed. Even though I just read that the realtors were giving up their 6%, and anybody knows that realtors were charging 6%, we could never discuss it as a group
Yep.
because it was potential for price fixing. And when you've got independent, and I think the domestic workers would come under.
Well, they may or may not, because there are domestic workers who are employees as well, as opposed to those who operate in effect as independent contractors. In fact, there are issues of it being improper to allow them to act as independent contractors based on the definition of an independent contractor. And that goes to the issue of, you've got workers, for example, who have no protection for unemployment and who have no ability to do a number of things that you know, for example, having workers' compensation insurance is the thing that most comes to mind.
Well, yeah, all the people that contract out to do house cleaning, and you might do 2 to 3 houses a day, 5 days a week.
Well, the definition, though, the federal definition, and I assume it's carried through Vermont, of an independent con, we have laws regarding what is an independent contractor. And there's some things that the employer has the right to tell you what to do, that you do not supply your own equipment, the employer supply, all of those things are characteristics of employees, regardless of what you call them. And my question is whether or not this particular bill extends the rights contained in this bill to everybody, including domestic workers and so on, who are not mentioned in the National Labor Relations Act, because this doesn't say anything about the National Labor Relations Act. It says solely what we do here.
So we can't, for the workers, the types of workers covered by the National Labor Relations Act, the federal law has occupied the field except where they've created room for the states, which is public sector workers, and then some of these types of employees who are specifically excluded. I don't think that this could be read as extending collective bargaining rights to, for example, small workplaces that are excluded from the NLRA. So, for example, if your workplace is so small that it doesn't make sense to have a union representing your 2 employees, you're not covered. Even under state law, your workplace has to hit a threshold of 5 employees before you can collectively bargain. So if we look at the National Labor Relations Act, under the definitions here, we can get a sense of who's covered and who's not. So employer is any person, but does not include the United States, a wholly owned government corporation, Federal Reserve Bank, or any state or political subdivision, or any person subject to the Railway Labor Act, but that's another federal law that supersedes state law, so we can't provide rights to railway or aviation workers that who are covered by the RLA. The term employee includes any employee of an employer, unless they're specifically excluded. And then if you head down, and then you have to be actually in interstate commerce. So that's where our State Labor Relations Act comes in, and the off chance that there is still a few Vermont employers who don't work in interstate commerce. But
Well, like I
then,
said, it goes to the kinds of questions that I'm asking. For example, if you have a domestic employee, that person doesn't work in interstate commerce. And that employee is on your payroll, is on your workers' comp. Is that an employee under this law?
I, don't want to question Damien's ability to keep answering these questions. I just want to interject to say, we are going to have, hopefully, if we can reschedule properly, in Illinois, a national labor attorney come tomorrow that I think could help answer these questions. He's a nationally recognized labor attorney who teaches and knows Illinois' amendment well. And we're gonna have Nate Mickenberg, so I think
I would
there's
like to
a,
have an attorney who knows Vermont law.
well, we did have that, and the problem is we don't have a lot of Vermont labor, David Mickenberg is a Vermont labor attorney. The Rich Cassidy is one, and he's scheduled to come in on some different matters in the future, but we don't have a lot of,
Well,
Vermont labor.
I'm asking you, for example, are fire workers covered under this constitutional amendment?
so right now,
Yeah, we already did that
Yeah.
last year.
I thought we did.
well, so
Yeah,
that
we did.
only if it passes the House and gets signed by,
Oh,
so.
thank you for reminding me.
I know, it would be nice to be a unicameral legislature sometimes, right?
Time.
But that bill is in House General right now. They have had some testimony on it, but they haven't taken action yet, one way or the other. So I think as I read this, there's an argument. I don't know how a court would rule that, for example, for employees like agricultural employees or domestic workers could make an argument. You do have to have an employer, and that's where the problem comes in for independent contractors. So for example, if you're a freelance, whatever it is, web designer, writer, that sort of thing, you likely work for multiple employers, and you likely also set your own terms of employment, but your employers are not providing you necessarily with a permanent workplace, benefits, et cetera. Although you may negotiate
Well, I
for,
mean, there's
you know.
specific guidelines as to what constitutes employee and leave
So-
both in Vermont law and in federal law.
and it varies actually by statute. So independent contractor, we have some statutes that use the ABC test. We have other statutes that look, so the wage and hour statutes are notoriously broad. So it's suffer permit to work, which literally means anyone you allow to work in your place of business who's not clearly the employee of another person is your employee. But in other cases, we're looking at, is it in the course of your business? Do you have control over them? And are they regularly independently established, or is this basically what they do? So your independent contractor only works for you. They work in the course of your business, and you control what they do on a day-to-day basis. That's not an independent contractor under the ABC test versus, for example, the person who comes in to renovate your storefront. They're not selling goods. You've just told them what you want the project to look like, but they control the day-to-day process and they're independently established. They might go work for your competitor across the
There's a
street
business
too.
doing that,
Right.
as opposed to someone who's working effectively solely for you. They may have a part-time job with someone else, but they're working for you. You supply the equipment and it's done on your premises. It's done entirely at your direction, as opposed to the independence that a contractor would typically
I
This
think
is something that
the,
we run into all the time here as to what's an employee in Vermont, and it doesn't seem very settled.
but I think the difference is that it varies from statute to statute. There is case law on who constitutes an independent contractor for purposes of collective bargaining.
Mhm.
One of the issues, Senator Cummings brought up, the independent care providers. So they are what are called quasi-public employees.
Mhm.
They are controlled, their day-to-day actions are controlled by the individual that they provide services to, so that's the person who has the right to control. But if you look at their wages are paid through a state program that's funded by state appropriations. And so in that case, we passed a law that allows them to negotiate just on those wages, because we can't control their conditions of work. But we can control their wages, and so they can negotiate as a union on wages. In the case of the agricultural workers and domestic workers, if you have an instance where you have a large enough domestic workforce, you could potentially have an argument from them that they're entitled to collective bargaining rights under this amendment. I can't give you 100% answer on how our court would rule on that. Same thing with the agricultural workers, assuming you don't pass, I think it's S-102 is the bill that passed out of the Senate last year, just sitting in the House. I think independent contractors are not likely to ever fall into that category of employees who have a right to collectively bargain. Is that what we say, that employees have a right to organize? They would have to be able to argue that they're an employee, and in which case we're back to the question of employer independent contractor, not that we're granting collective bargaining rights to independent contractors. I think also where the federal law has said we're covering these employees in interstate commerce, but we're not covering workplaces with fewer than X number of employees. I don't think the state can step in there and say, we'll cover them. I think that's a preemption issue and the federal law preempts.
You're saying essentially that the federal law, in terms of how it defines employees, restricts us from broadening the state law to cover things like farm workers?
No, I think we can cover farm workers. I think we can't cover, so for example, the federal law covers retail workers. I think we can't extend where the federal law is set in a retail workplace with X number of employees you can collectively bargain, but with fewer than a certain threshold, you can't.
That's according to federal law.
Yeah, so I think where the
So
federal
we
law
can't
is set,
extend it
we're
down.
covering collective bargaining for like most workers in interstate commerce.
So in other words, we're restricted to things like the total number of workers in workplace in a particular industry on the basis of what federal law says, and we can't extend it further to the state.
Right, because federal law,
Even if it's not done in interstate commerce?
we can do, if it's in intrastate commerce, so within Vermont, we can cover that. We already do under the State Labor Relations Act. And the proposal that you passed last year would have added agricultural workers and domestic workers to that. So I think my answer to your question is, I think there is an argument that in areas where the federal law has not preempted us from acting, that workers could argue that they're entitled to a right to collectively bargain. This, but it's impossible for me to know exactly how the court will rule. So there's the question of, is this a self-enforcing amendment, or are they going to rule that this requires legislative action to grant those rights to a further extent? And I can't answer that, and I'm definitely not the constitutional scholar that Peter Teachout is, and that others are. So, but I think that would be the question, basically, is
Part of the legislative council's office.
So it's a little past noon. We are gonna devote an hour to this tomorrow from 11 on and move the other topics. And put the vote on for tomorrow. I will say I have invited Bill Driscoll. I've heard from both chambers that they do not want to testify. I made sure I was characterizing it properly. The Vermont Chamber values your line of questioning about could this have unintended consequences, et cetera, that we're gonna keep trying to address that tomorrow with this Illinois labor attorney, especially around educational reform, because as I said, Illinois does a lot of educational reform, and I don't think it's been impeded by this bill, but we'll talk to somebody there. David Mecklenburg will talk about the national context as well, and is a Vermont labor attorney. So Bill Driscoll might be added to the list, and that's who we have invited tomorrow. Damien, I'd love if you could be here. It's
I'll-
moved, so I don't know.
I'll do my best.
It was helpful today.
Yeah, we're in the thick of markup on the
Yeah.
bill, so.
Yeah.
Um,
Whether or not people vote for it, I don't see any language changes on the horizon, right? Just because we might not have Damien. Okay, so we'll go off live. We might not have Damien tomorrow.